Don't panic. And if you have been hacked, definitely do not wipe everything and pretend it didn't happen.
In Australia, paying ransomware is not actually illegal.
Specifically in relation to ransomware, there is no blanket prohibition on paying a cyber ransom, but you must not make a payment to a sanctioned person or agent. A glossy privacy policy, it's not a shield. It's only as good as what you're actually doing with it. Have an incident playbook. Have contracts. Contracts aren't your enemy. In fact, they'll probably make you look more sophisticated and more professional.
You can outsource the job, but you can never outsource the blame. Kirsten, you've spent 20 years in rooms that most cyber people never get near. Defense, aviation, mining, big projects. And somewhere along the way, you decided the most dangerous thing in cyber wasn't the hacker. It was the contract nobody reads. So for everyone listening who has no idea who you are, how do you introduce yourself today?
Well, you make me feel really old saying I've been at this game for more than 20 years, Bora. But yes, that is true. I'm a lawyer, obviously, and have spent a lot of my life in contracts and looking at contracts and advising now small businesses in the main around their supply chain and the fact that they don't have any contracts or they put that contract in the bottom drawer. And I guess from a cyber perspective, the supply chain and the contracts is a big risk. And we've seen that over the time that we've been practicing. Mining, defense, aviation, big projects, critical infrastructure, big risk, lots of personal information, lots of supply chain risk. I guess during COVID, we saw the supply chain risk escalating as well. And that's just becoming, with the way that things are globally, more and more of an issue. So having those contracts that are really quite solid and protecting not only the commercial deal, but understanding that cyber posture through the supply chain is becoming more and more apparent and more important. So yeah, I have started to focus on that for my sins.
And I guess that's such a big advantage to small businesses because you've seen what happens in all scenarios, whether they're big or small. So that's a big advantage, I think, for most people. But let's be honest, when most people hear lawyer, their eyes glaze over, they brace the expensive or boring conversation. But I guess what I want to know is, what did you see across all those years that made you go, cyber isn't actually an IT problem, it's a legal one, and nobody's treating it that way?
Well, I would suggest that we've moved from cyber being an IT problem to being a legal problem, but now more broadly a board problem and an executive problem, which I think is where the conversation needs to go. There's no such thing as a commercial legal issue in isolation. A legal issue, by definition, has reputational, commercial aspects, reputational and insurance aspects to it. So that a legal issue doesn't exist in a vacuum. And what I've seen, particularly around when something goes wrong, whether it's as you've been hacked or a contract is in dispute, the first thing that is don't panic. Don't panic. And if you have been hacked, definitely do not wipe everything and pretend it didn't happen. So the value that lawyers bring when something does go wrong, whether it's a contractual breach or a cyber breach or a privacy incident, is really focusing on preserving the evidence. So we're looking at it from a lens of, this is what's happened is terrible. You're panicking. We bring a calm focus to it, and we help preserve the evidence in such a way that if we need to look at it from a regulator's perspective or from a litigation perspective, we've got a really good evidence trail there. So while the technical people are looking potentially at cyber incident response at what systems and what data has been affected, we're holding their hand along that journey to make sure that we've got the evidence, particularly very early on, to decide whether it's a legally notifiable event, for example. It's similar with any other major project as well, where you do have disputes and you vary contracts over time. Having a really good audit trail is probably the key thing that lawyers bring to any transaction or any issue. Because later the regulators and the courts are going to ask simple questions like, were your steps reasonable in the circumstances? And if you can't show a structured assessment, you're starting on the back foot. And having measured, documented assessments that justify your decisions. And if we again talk about a cyber incident as an example, if you have that audit trail that shows why you made certain decisions about notifications, for example, or what remediations you took, what communications you engaged, that sets you up in really good stead and helps avoid one of the main pitfalls that we see, which is either overreacting and creating unnecessary legal risks down the track.
Yeah. We are going to get into all that, I promise. There's quite a few questions on those, but I want to play this out, right? So we're talking small businesses. I'm a cafe owner, or I'm a Sparky, a builder, or a mummy daddy business at home, right? It's Monday morning. I walk in, half my systems are locked out. Now, there's a message demanding money, and I'm freaking out, as you said, because that's what we do, right? As small businesses, we love freaking out. I call you. Now, what does the law actually expect me to do first? And what am I about to do that's going to probably make it worse?
Okay. Specifically in relation to ransomware, there is no blanket prohibition on paying a cyber ransom, but you must not make a payment to a sanctioned person or regime. So the first thing, if you're even considering paying a demand like that, we need to do some checks. So we need to, again, stop, don't panic. You got your technical people doing their technical thing. They're stopping the bleed. They're looking at the root cause. We're looking at, okay, what are we going to do with this demand? And the first check that you would be doing is, are there any sanctions that apply here? Because the law carries very serious penalties for breaching sanctions. So you're a small mum and dad coffee shop owner, so you don't have a board, you don't have an executive, but we need to treat it still as a high risk governance event. Even though you are a mum and dad coffee shop owner, you still have those same obligations. So I'd be wanting to assist you with documenting those risk assessments, looking at alternatives and doing those sanction checks to ensure that if you do approve a payment, there's a rationale. I'd also want to be talking to you about what insurances you have in place, because insurers require prompt notification. They might even require cooperation. I find a lot of people in that scenario, Bora, don't have sufficient insurance or the right insurance. But if you do have insurance, you need to make sure that your insurers are notified straight away as well, and that you're complying with any of their obligations. If you do have insurance, you have an insurance contract, and that insurance contract will set out exactly what you need to do. And if you don't follow those steps and you don't tell your insurer, you can later find yourself uncovered. You can jeopardize that cover for incident response. You can jeopardize cover for business interruption. And you can even potentially jeopardize cover for your regulatory defence costs. So that would be the immediate things that I'd want to be working through with you. I'd be talking to your IT providers and your MSPs as well, if you have them. And obviously, after we look at the demand, because that probably will come with a tight timeline to put pressure on you, to stress you out and make you panic and make you pay the demand. After we work through that, we'd be looking at that 30-day assessment period and making sure that you're doing all of the normal steps and identification, containment, mitigation steps.
Yep. You got me thinking. Two things.
No, did I? That's scary.
It hurts. Stop it, please. What you said the right insurance in place. What is the right insurance in place mean? And I'm guessing we're going to talk between cyber and regular. And even for that matter, for when we speak about DLC, what is the difference between, like you say, go to a lawyer, but who's the right lawyer?
That's a good question. And there is no one size fits all when it comes to risk assessment and insurance. And there's certainly no one size fits all when it comes to lawyers either. When it comes to choosing the right lawyer, I would suggest that after a certain level, there's an expectation that lawyers are competent. I think the most important thing is, can you work with this person? Does this person understand my industry? Is this person likable or even easy to communicate with? I wouldn't be choosing a family lawyer to be advising on contracts or criminal law, and I conversely wouldn't, see to like choosing a GP over a surgeon as well. Choose the right lawyer for you and your circumstances. If you need lawyers frequently, that relationship becomes more and more important. And there are different models. As you know, there's top tier law firms that are, very heavily resourced, and there are smaller, more agile firms like DLC that get to know your business a bit better, a bit more deeply, and partner with you so that it doesn't matter if you're picking up the phone saying, I need a new privacy policy, or I need to terminate this contract, or this supplier's not delivering, or, worst case scenario, we've just received a ransomware request. What do we do? If the lawyer knows you and knows your business, that's the most important thing, I think, when it comes to choosing a lawyer. You want somebody you trust, you want somebody you have confidence in, and you want somebody who understands your business.
Yeah. And that applies to everyone, right? At the end of the day,
Correct.
trust is number one.
Yeah.
Trust is number one. You want that relationship. And if you build trust, when someone does something, they're likely to tell you. If you don't have trust,
Yes.
they're likely to blame or something or someone and hide the fact. And that's a cultural internal thing. But I agree. When you walk into a cafe and the guy making the coffee says, ask you something personal that he knows about, it just makes that difference.
Yeah. Yeah. That's exactly right. I once walked into a coffee shop that I'd probably only been in half a dozen times, and I ordered a flat white, and I got a very strange look. And she said, "Oh, I'm sorry, but you ordinarily order a long black." And that just made my day. It just really made my day. It's like, oh, that's true.
Yeah, it does. Now, you mentioned, just to clear the understanding, so you mentioned the term SMB 1001, which is just for people listening, it's a framework that your business can follow to comply with different levels of cyber. So they have bronze, silver, gold, and then they've got diamond and platinum, I believe it is. But the purpose is that if you follow that standard and you have a professional help you put that together, as a part of that, needing a good lawyer is one part of that as well. So you are less likely to be in a scenario that you're going to be rejected if you comply by that standard and that framework, which I think is a very smart way to do things, and it's doable. It's not complicated. It's not going to cost you $1 million, and it will, the level you get will depend on the business that you're in. Here's one I think most people get wrong, and based on what you mentioned before, in Australia, paying ransomware is not actually illegal. Now, most people, and I'm going to admit until maybe even a couple of years ago, I was on this boat, thought that was the case, but it isn't. But it can turn into a very serious crime the second the money lands into the wrong hands. So in plain English, when does paying cross the line?
If you think about Russia first invaded Ukraine and global community responded by putting sanctions on Russia. So that meant that, and both certain imports from the country and people. So if we think about it like that, if we are paying a ransom to a person who is under one of those sanctions, then we can get ourselves into strife. And that's where you probably do need a lawyer to help you with those due diligence checks. And whilst there's no blanket prohibition at the moment, that's not to say that won't be the case in the future. The legislators are looking at privacy laws and cyber protection and how the carrot and stick approach needs to work to ensure that among the Five Eyes countries, so there are countries that Australia trusts and works with, and they're called the Five Eyes. So our legislators are working with those countries where we've got trusted partnerships, trusted relationships, to change the legislation in a way that incentivizes people to report and to be protected, to not pay ransomware. So whilst it's the case at the moment, it might not always be the case. And so whenever you receive a demand, I would suggest picking up the phone to a lawyer. And most lawyers, if you haven't got a lawyer, most lawyers are happy to give you a free 15-minute call, but it'll give you some very quick advice on do or don't, and then take it from there. So it's if you are paying money to those sanctioned people or organisations, you can get yourself into some serious criminal penalty territories. So that's what we want to avoid.
Yeah. And I believe, now correct me if I'm wrong because you're the expert, if you're turning over more than 3 million as a business, then you must by law report that you've been compromised or you're in a ransomware or you've been hacked, right? But the real question is for the small operator who's listening, the cafe or the plumber, the one-man band or two-man band, mummy daddy business. Now, they going to listen to this and they're going to say, well, that's not me. What does apply to them? And what's that trap that they fall into by assuming they're too small to matter?
So there is the small business exemption and the $3 million threshold. Again, don't assume that that's going to last forever. But when we're looking at a cyber incident, there's two things that we're looking at. One is what data was compromised and whether it is personal information. But then secondly, is the breach likely to cause serious harm? And that twofold test is the trigger. So not every cyber incident is automatically a notifiable data breach. There first has to have been unauthorized access, disclosure, or loss of personal information. Then secondly, it has to be likely that that compromise will cause serious harm to individuals. And then under the legislation, under the privacy legislation, there's carve-outs that the legislators have decided the information is sensitive. So if the information relates to your health, for example, if health records are considered sensitive, so they would automatically cause a lawyer or a business owner to think, I've been compromised, and part of the data that's been compromised, if you're a not-for-profit, for example, in the healthcare sector, is health information. That elevates it almost immediately to the next level. So you're assessing both what information was involved, how sensitive it is, and what the realistic consequences might be. So, for example, exposure of names and email addresses is one thing, and it's probably at the lower end of the scale. Exposure of health records, as I mentioned, financial data or identity information that could lead to identity theft, that's another. So we're doing that assessment very early on, and that risk-based test is why really, really good fact-finding in the first 24 to 72 hours is critical, because you do have 30 days to assess, to make that assessment. So you need to know who to call. Like on day, is it 0 hour, right? You need to know who you're going to call before the incident. If you've got a simple register for a mum and dad business, just have a simple register. Are you in a regulated industry? Do you need to contact a regulator? Do you have a lawyer? Who's your cyber expert? Your MSP, are you going to call them if you've got one? Just having those contacts and having that call list is really important in that first 24 to 72 hours. So that when something does go wrong, your legal and your risk teams can respond quickly and cross-check the facts of the actual incident and make that assessment around whether the type of information that has been compromised would be likely to lead to serious harm to individuals, which triggers those notification obligations.
Yes, it's definitely an interesting one, isn't it? One thing that we see is with a lot of businesses is policy. So they've created this policy, which might be a privacy policy. They've slapped it onto their website even. And this may have been done years ago for that matter, right? So this is a two-part question for you. So first one is that policy, I guess, worthless when there's a breach, if you get hit by a breach? And simple fixes like, are people collecting and hanging on to data that they never needed in the first place? Like, how does that play out for you?
Okay, I'm going to answer your second question first. We are going to be moving down the path more like the European model, where we have data destruction laws come in. And we know that for ATO purposes, for example, we need to keep records for 6-7 years. But the next tranche of changes are likely to include a right to have your information deleted and also document personal information destruction policies. Coming back to your privacy policy, and good plug for Luke. Luke will tell you that a glossy privacy policy, it's not a shield. It's only as good as what you're actually doing with it. So notifiable data breach scheme and the Privacy Act requires us to look at what you actually do in practice, so that governance, your security controls, baking in the governance, ensuring you're doing training, making privacy and cyber part of your ethos and your governance structure, minimising the data that you hold. To your point, typical legal gaps are where there's no accurate data map, or where you've got weak vendor oversight or over collection, as we've touched on, and indefinite retention. So I'm suggesting that we're going to see some changes legislatively around over collection and indefinite retention. But if your practices and your processes don't match up to your privacy policy, then it's going to look behind that piece of paper, so to speak. And if you've got poor breach response processes, so your privacy policy should sit next to a very good incident response plan, and your incident response plan should be tailored for your organisation or your business. It should set out the who, what, when, where, how. The other thing to think about when it comes to your privacy policy, if your policy promises higher standards than you actually meet, for example, if you have written into your privacy policy that you meet industry-leading security standards, but you actually don't, let's just say you've got no testing, or will immediately notify you, but then you sit on an incident for, a week, that gap becomes evidence from a legal perspective and can constitute misleading conduct, and it can amount to a failure to take reasonable steps. So having the policy is important, having the response plan is more important, but living and breathing that from a governance perspective, and particularly where you are holding more sensitive information, there's less tolerance, and regulators are becoming more and more intolerant for having bare minimum policies bolted onto an underfunded security program, for example.
Yeah. So I'm a business that doesn't have a choice. I'm a mortgage broker, I'm a bookkeeper, or I'm a legal firm for that matter, right? I have to, for some reason, hold your license, passport, bank details. Now, they can't not collect this because they have to for what they do. What's your advice to these guys, with regards to when they have this information?
So under the Anti-Money Laundering Act Tranche 2, a lot of those industries that you've just described are now AML reporting entities, so anti-money laundering reporting entities. So we have to, when we're onboarding a new client and we're taking your personal information, we have to do certain checks around money laundering and knowing your customer, that sort of thing. So on the one hand, you're a regulated industry and you have to do those checks, which requires you to collect personal information. Doesn't mitigate your obligation to manage that personal information in a way that's reasonable. And so coming back to there's a budgetary argument here, a budgetary consideration, but if you can't protect the personal information, I would suggest that you don't operate in one of those heavily regulated industries. You need to be able to demonstrate, regardless of your size. There's a lot of sole practitioners in the legal industry, right? They're one man or one woman band, and they might have an MSP and that's about it. But if they're operating in family law or criminal law, they're collecting a lot of sensitive information, a lot, financial, identifiable information, potentially criminal history, health data. So they need to ensure that the measures and the controls that they have in place are commensurate with the risk. And that might mean spending more budget on becoming SMB 1001 Gold certified, for example, and having controls in place to be able to demonstrate that you are acting reasonably. Lawyers are notorious for retaining information, and I would suggest that any law firm, smaller or larger, that has been operating for more than 5 years or so, have a look at their data and potentially consider data cleansing activity. So have a policy with an automated system if you can around destruction within a reasonable time frame. So understanding your data retention obligations at law, depending on your industry, and having those controls and practices in place.
Yeah. You touched on something before that I think is very important. You first mentioned the supply chain hack, which effectively is where you're compromised through a third party, right? The usual case for most smaller, medium businesses is either if they've got, as you said, a managed service provider or an IT company, or they've got, I know, like in your industry, there are various softwares that are the main programs that are used where the data is kept. So it's not on your own servers or your own computers. It's kept in a server environment in the cloud. It could be Microsoft even, it could be Google. What happens if they get hacked and that's how I get hacked at that point there? My question is, if the criminals now have my data because that third party was compromised, when the dust settles, the question that everyone's going to ask is, whose fault is it? And what should I have been, or what should I have in my contract so I don't fall into this situation?
That brings us full circle back to your very first comment about my focus on contracts. And I am very passionate about contracts. I'm a contracting nerd, self-certified contracting nerd.
Nerd.
Nerd, fellow nerd. Many breaches now do start in the supply chain through MSP, remote management tools, as you mentioned, vulnerable software updates, poorly secured third-party portals, back-end website updates, all of that sort of stuff. But customers still own the legal risk. So if personal or client data is compromised, I had a really curly one the other day, got a call from a friend saying, particularly if this happened, and it was so circular. And through the supply chain, there was fault everywhere. And if you don't have a contract in place that assigns responsibility and liability, then the fallback is common law. And the common law will look at all of the players in the supply chain, look at all of the circumstances, and will allocate proportional liability depending on the circumstances. So you could find that more than one party in that supply chain is liable and is the victim and responsible. And that is becoming more and more the case in what I would, describe as supply chain roulette. Having those really good MSPs, your master services contracts, your SaaS contracts or your services contracts is where you can assign responsibility and liability. And that's when you've got it in writing, you know who's insuring, you know who's going to respond, you know which party is going to take ownership. Contracts with MSPs and software vendors, they often underspecify the obligations. So there's no minimum controls or standards written in those agreements, or you've got parties wanting to limit liability aggressively and say almost nothing about the actual incident response. So when it does happen, you're like, oh, but I thought you were doing that. No, I thought you were doing that. No, having that, it's a bit like your incident response plan. Internally, you want that to be really clear through your supply chain so that you know that you're not going to trip up and miss your notification timeframes if they apply. You know that your supply chain is going to cooperate with you and who plays what part and who bears what cost. So from a legal risk perspective, what you want in those supply chain contracts is very clearly defined security standards, audit and assurance rights, for example, and prompt incident notification with those cooperation duties spelled out. so that you've got an allocation for of forensics, for example, and notification responsibilities and costs. We see a lot of misunderstanding around whose responsibility it is in those scenarios, and those reporting deadlines get missed. So that's why I am passionate about having those contracts in place and addressing that a little bit more, in a little bit more granular way. And if you're contracting with government, for example, then you can expect that as a norm. And a security risk assessment of your entire supply chain from the procurement process before you even get into contract. But we also deal with the other end of the spectrum where we've got clients who have been operating for 20 years and have no contracts in place. So the obligations still apply, the law still applies. It just might make it a little bit murkier in terms of where that liability sits, who's going to bear the brunt, and opens you up for, I guess, more risk in terms of disputes and litigations.
Yeah.
So boards are now looking at that vendor risk as part of their overall cyber governance risk tiering. I would suggest that small businesses need to understand their supply chain as well and just be clear on who's holding what information and who's responsible if there's an incident.
Yeah.
Because it can be more than one party, as I said. It can be both parties victim, both parties responsible.
I guess you can say you can outsource the job, but you can never outsource the blame, right?
And that's right. That's right. The obligation. Yeah.
The obligation. And I agree. I like to say personally, when I speak to a small, medium business, that at the end of the day, cyber needs to be a part of your culture now. Ultimately, forgetting about all of that, it's, have I, hand on heart, done the best to my ability to minimize the risk of that data being compromised? And if so, then I can sleep at night, is the way I put it. So when someone says to me, oh, that's too much money, or that's, why do I need this and why do I need that? It's like, that's what it comes down to for me. It's, listen, if this happens, and as you suggested earlier, this could bankrupt your business. It could ruin you financially. It could ruin your reputation, which is even worse than financial loss for a lot of businesses, especially with trust. That's what kills you.
Once it's gone, it's gone. You can start a new business, but your personal brand and your personal reputation comes with you. So it's a typical lawyer's answer that non-lawyers get frustrated with. It depends. Do a risk assessment.
Yeah.
Know what data you hold. Know your obligations. Have a look at what industry you're in, and do you have additional obligations? And then decide how you want to manage that risk. Operate a business without accepting some risk. And this is, unfortunately, just one of those risks that we need to consider in operating a business. And I get a lot of frustration from smaller clients who just want to get out and do their job and do a good job. They can't sleep at night because they're worried about just like a cyber incident, and they haven't got the budget to put all of the bells and whistles in. But again, that circles me back to SMB 1001, which is specifically designed for small businesses, and it's not prescriptive, and it does help, I think, the right technical people advising you. And after you've done your risk assessment, I think it does help every small business to at least say, I looked at this and I implemented these measures within my budget because I only collect names and email addresses. I don't collect driver's licenses or sensitive information of any kind. And I've got a policy in place that we religiously implement that deletes data when we don't need it. And then you've got that legal protection, looking back with hindsight to say, I did my risk assessment, I implemented measures that are reasonable and aligned with SMB 1001. And that's exactly what that's designed for. So that your small businesses aren't trying to implement ISO 27001, for example, which is hugely cost prohibitive.
Yeah, absolutely. And we've covered a lot. It's amazing. We've spoken about ransom, we've spoken about blame, contracts, and what can and can't go wrong. So if there's one thing this week that the listeners can take away, what is your advice?
Have an incident playbook and have it printed in more than one location. And obviously, two things. Have contracts. contracts aren't your enemy. They're not the enemy. They won't stifle the deal. In fact, they'll probably make you look more sophisticated and more professional.
There you go. Yes, have contracts. This is from the contract nerd queen herself.
Contract nerd queen, my new title.
Okay. So, last question then. If I handed you a pen and you could rewrite the law, one change to how Australians handle cyber breaches, ransomware, any of that, and it takes effect tomorrow morning, what are you writing in?
I'm writing in incentives for and collaboration. And when I say collaboration, I'm thinking about that Domino's example that I alluded to earlier. That's a known risk. My bank knows about it. My bank was on top of it, but there doesn't appear to have been coordination. And I would, especially at that high end of town where banks are making ridiculous amounts of money off small people, small businesses, I would be writing in an obligation to be more transparent and cooperate so that we understand the threat environment better. And that's the law. I think the regulators could be a little clearer in terms of providing guidance around the thresholds, particularly for that likely to cause serious harm. I would like to see regulators being more proactive and helping small businesses comply, as opposed to just slapping on new regulation and new regulation and new regulation.
Yeah. Kirsten, I want to say thank you. I want to say thank you for all the work you do, how nerded out you are by contracts, and the fact that you understand and help so many small businesses as a firm to, what the big level people are doing and what they should be doing, but explain it in such a way that it makes sense to them, regardless of how, as you suggested, frustrating it might be, and everything you guys do. So, big thank you for coming on Dumb Ways to Get Hacked. And I genuinely look forward to the following episodes that I think we'll be able to do and advise small businesses.
Sounds good. Thank you for your time, Bora.